respect the difficult and often dangerous work that Portland Police Bureau officers have to deal with on a day-to-day basis. And I've been quick to praise their great work, even in the face of criticism. And backed up that praise with, even though I've had to cut in all three of my budgets, made sure that they were protected against deeper cuts other bureaus have had to endure. We put forward a number of new tools to help with peacekeeping, like the illegal gun laws,
right.
and funded I think it's like 20-year wish list item at the training center. So I know they work hard. They deserve praise. Huge improvements as well, and invested in giving them more of the tools that they need to do their job well. As police commissioner, though, I also have the responsibility for holding accountable those that don't follow our protocols, and especially protocols around the acceptable use of deadly force. And our standards in Portland for the acceptable use of deadly force by a police officer are more restrictive standards than other locales, are more restrictive standards than some of the national standards that have sort of been promulgated as a result of court actions. And our policy calls for restraint in the use of deadly force, for example, when officers are responding to a call to check on a person's well-being. We call that a welfare check. And that was the case with Aaron Campbell. And I believe, and the chief believed, that he violated our local standards on training and policy around the allowable use of deadly force in the Aaron Campbell case. The question has been, how and on what grounds do we have any legitimate grounds to get this issue in front of the State Employment Relations Board? And the city attorney has determined that we do have the ability and the grounds to get this issue in front of the Employment Review Board, and it's under an Oregon law that says that that the portion of the statute adopted by the Oregon legislature to limit the discretion of arbitrators and broaden the view of arbitrator decisions by Employment Relations Board. This case, this change in the law came as a result of the Erickson case in 1993. And that was a case where we had a police officer firing over 20 times, pursuing a suspect who was fleeing.
Right.
And we lost the arbitration. And so this state law says that when it's the use, among other things, when the use of deadly force is the cause of the discipline, then among other things, the Employment Relations Board should be more open to hearing those cases. So based on the city attorney's opinion, I'm not going to be reinstating former officer Frashour. I've had the opportunity to, there's been expensive media coverage of the police union president's remarks, including a show on OPB, consulted briefly with the Campbell family, spent a lot of time talking to the attorneys and to the police chief, and my decision has been informed by all of these people, and I appreciate their input.
At what point will you file paperwork? What's the next step? How does that actually get there?
Well, I've notified the union. Our attorneys will notify the Portland Police Association unions that as police commissioner, I will not implement the arbitrator's decision. They'll have the opportunity to file a complaint to the Employment Relations Board, and then the Employment Relations Board will hear the arguments of the matter, why they should review it, and on what grounds.
So that's the path. It'll be the city is not going to abide by the order. the PPA, it's up to them to decide if they actually want to be the agency challenging this for the BRB.
Yeah, one other thing to add is the police chief does not agree with me on this decision. And I obviously listened very carefully and had long and very serious conversations with him and the city attorney. But in the end, I made up my own mind, appreciated the vigorous discussion, made up my own mind, and our police force is, the oversight of our police force is an elected civilian who happens to be me, and in the end it's my decision to make.
I know, obviously, I talked to Commissioner Leonard yesterday, one of your own colleagues who said this might not have been a good idea. Have you heard that from other?
I've talked to Commissioner Leonard. I've talked to every member of council to explain my decision. It is my decision to make as the commissioner in charge of the Bureau of Police, as the police commissioner. If we need to appeal whatever an ERB decision might be on this matter to the appeals court, that would have to be a decision of council. This particular statute has never been appealed to a court, and I think it should be if the Employment Relations Board doesn't follow the clear wording of the resolution and the clear legislative intent. I've been around a long time, and every case that comes up, it's the union's responsibility to call into question the wording of our procedures and our policies. It's their job to find other people in the Bureau who have a differing point of view, who might or might not be familiar with the details of a case, and present them, as part of the arbitration hearing. That's their job.
Right.
But the Portland Police Bureau has always had more restrictive standards for the use of deadly force. We have, what former Officer Frashour did, and with the information that he had, because there are other problems, but the information that he had acted out of policy and procedure. And because it resulted, we found no malice, but because it resulted in the death of an individual, the use of deadly force, that kicks in ORS 243706, which was intended for this exact same situation. The details are never going to match,
right,
but the exact situation, and it was referenced in the legislative intent.
What reason did the chief give when he said he didn't agree with this decision?
Well, he thinks that the decision to bind ourselves to arbitration, that's his view, that our decision on arbitration, to use an arbitrator, is, that's been, frankly, the tradition of the Bureau. But I've been through too many of these. My view goes back a lot longer than a lot of other people's. And, I know that we promoted legislation at the state level that not all disciplines, that not all employment cases by public employees are equal. The use of deadly force is very different than, let's say, the inappropriate use of a government's computer. Those are very different things. And they should, obviously the use of deadly force should be held to a much higher standard. And it is under our local policies, and it should be and is under state law. Not many people are familiar with the state law. I am.
Is there any sort of timetable for when this can happen? Does that depend on the PPA?
It's dependent on, if the PPA is going to pursue a grievance, and it depends on, or a complaint, and it depends on how fast the Employment Relation Board acts. I'm going to ask them to expedite the process. But, and if we lose, we have to pay his back wages. We have to pay his back wages, now under the arbitrator's decision. Right. So this is not without potential cost. But Portlanders want us to stand up for the principles of restrictive use of force only when absolutely necessary. And state law says that when the public employee conduct in front of an arbitrator and in front of potentially the Employment Relations Board, that when the issue of conduct of a public employee is in front of them has to do with deadly force, this law applies. And they have, they have not embraced it to the degree that I believe they should.